Welcome back to ARBinBRIEF, your practical video guide on navigating key arbitration issues. My name is Karolina Latasz, and I'm a senior associate at 𝗔𝗥𝗕𝗙𝗙𝗏 in London. I'm also a member of the ARBinBRIEF team. Today, we'll explore what continues to be a highly relevant topic, the impact of sanctions on commercial arbitration. Joining us are two fantastic speakers with a wealth of knowledge on this subject. It is my pleasure to introduce you to Natalie Reid and Vilija Pavan. Natalie Reid is an international dispute resolution partner at 𝗔𝗏𝗕𝗙𝗏 based in New York, and she co-chairs the firm's Public International Law Group. Amongst her many affiliations, Natalie is a member of the ICC Court of Arbitration and a board member of the LCIA. She speaks and lectures on international disputes at leading universities, including Yale, Columbia, and NYU. Vilija Pavan is a partner at Alex based in Vilnius. As some of you might have seen, only yesterday, Global Arbitration Review reported that Vilija is defending Lithuania in a $12 billion investment treaty proceedings brought by a sanctioned Belarusian company. For more than 15 years, Vilija was the head of dispute resolution practice at Alex. Alongside her counsel role, she frequently serves as an arbitrator. Vilija was an ICC Arbitration Court member for Lithuania and is also the honorary consul of the Grand Duchy of Luxembourg. Turning back to today's subject, economic sanctions have been a hot topic for a while now, and there are no signs of this changing anytime soon. Just last week, the US imposed a new wave of sanctions targeting Russia's oil and gas sector. More measures, not limited to Russia, may be on their way too. As overlapping sanctions regime create a web of challenges, we're delighted to have Natalie and Vilija discuss how these developments affect commercial arbitration and how we as arbitration practitioners can effectively navigate these complexities. So let's jump right into it. Vilija, on a macro level, could you please introduce us to sanctions and provide a brief overview of their source, nature, and scope from the European perspective?
Thank you, Karolina. Thank you very much. Good afternoon, good morning, or good evening to everybody, because I understand that the audience is from all over the world. So I guess that if the audience already joining this seminar, so that do have some kind of general knowledge, but on a very, very high level. So the sanctions, it is measures against state or state-owned or non-state-owned entities, natural or person or legal entities that pose threats to such kind of fundamental principles as international peace and national securities. So the main purpose of sanctions is to put economic pressure on those targeted or states or natural persons in order to change their behavior and to change their decision makings that are putting threat again to the international peace or national security. So the target can be state, or target can be an activity or legal and natural person. There are different types of sanctions. There are the most, let's say, popular, at least at the moment in our part of the world, there are financial sanctions. The trade sanctions could be also travel and visa sanctions. So the purpose of the financial sanctions is to limit possibility of those targeted persons to use their financial funds and to get any benefit. In fact, the majority of listed persons under the financial sanctions, they are regarded as a persons or companies that paying lots of monies to the budgets of Russia in our part of the world, or Belarus, and those countries they are regarded as aggressive countries, and by more you pay to their budget, more they become powerful and able to get and to buy more weapons. So in relation to Russia, the main sanctions are EU sanctions imposed from 2014 after invasion to Crimea. So there are two different EU sanction regulations. One financial sanctions and one economic sanctions. In relation to Belarus, so there are sanctions imposed already even earlier, that is from 2006, and there is only one regulation, but both combining and economic and financial sanctions. So EU sanctions, they have only territorial effect. So all natural and legal persons that are residing or acting in EU, they are obliged to comply with sanctions imposed by EU. Apart from EU, might be some other sanctions imposed by some other organizations, for example, UN. Also might be some other particular countries, they impose the sanctions as US, UK, but not in all situations. Those sanctions, they directly are impacted by any activities in our part of the world, let's say, unless, for example, the payments, they have to be done in US dollars or in pounds. In such a case, they have to go through the banks in those countries and the payments can be stacked. So the main purpose, in fact, is to put economic pressure to those persons, which again pose threats to our international peace and national security. And to my personal opinion, it's quite a good instrument to fight with those not anti-democratic regimes.
Thank you very much, Vilija. And Natalie, from your perspective, how does the US approach differ or align with the position in Europe? And I think the elephant in the room, how do you see the future unfolding after the recent change of administration?
Thank you very much, Karolina. And again, my thanks to you and others in ARBinBRIEF for having Vilija and me speak on this topic. I will start with the elephant in the room, perhaps. Sanctions of various kinds, and I agree with Vilija, sort of the range of types of sanctions that she identified have historically been a critical tool of statecraft for the United States, regardless of the administration. What you might find is difference in emphasis or a difference in the flexibility of the regime and the enforcement thereof, but being able to use different types of sanctions in furtherance of the policy goals, whether of the United States unilaterally or as part of a broader multilateral effort, I think will remain very much in play. Perhaps the other elephant in the room is, and Vilija touched on this, there are a number of jurisdictions in the world who participate in sanctions regimes as part of multilateral efforts. The US is probably the world's leader in unilateral sanctions regimes as well. Because of how critical, sort of this ability to use sanctions has been as this, sort of tool by which the US seeks to accomplish its foreign policy. What that means, and if you think about how broadly the intent is to have that impact, is, for example, unlike the territorial restriction that Vilija mentioned, many of the US sanctions regimes, whether unilateral or multilateral enforcement, are designed to be as global as possible and have extraterritorial reach. So, for example, if you think about who is captured, covered, and required to comply with the sanctions regimes, it includes not just US persons, and that's natural and legal persons, but also, if we think, for the example of law firms, I know that we'll speak about this shortly, the foreign offices of US incorporated firms, organizations, and institutions also fall within that scope. And because, frankly, how central the US dollar is to the kinds of transactions that we encounter in international commercial arbitration, as Vilija mentioned, anything that is in US denominated transactions will also risk being, sort of captured by US sanctions regimes. That, of course, has an implication for the impact that US sanctions, UN sanctions, multilateral sanctions have on international commercial arbitrations. So perhaps as a bit of a teaser for things that we will, get into in a little bit more detail. the increased resort to sanctions by different states or international bodies means that they will have impact on our work in a number of different ways. One, we have seen an increase in disputes that arise because of sanctions regimes, right? If the intent of the sanctions regime is to put economic pressure, as Vilija mentioned, they are most effective when the target of those sanctions regimes are entities or states that are involved in international commerce. The halt of that will inevitably give rise to disputes. And the financial sanctions, of course, will impact the funds flows that would be necessary to facilitate arbitrations going forward. The way in which it kind of plays out will vary by participant or stakeholder. So I know that we'll get into that shortly.
Thank you so much, both. So now zooming in onto our arbitration microcosm. Vilija, as you've said, these sanctions are designed to inflict pain and police compliance with international law and eventually instill peace. But what are the key challenges that arise when a party involved in arbitration is directly or indirectly affected by sanctions?
Yes, thank you, Karolina. Indeed, as Natalie said, in fact, the number of cases involving sanctioned persons, being it claimant or defendant, is constantly increasing. And it's quite probably logic why, because the absolute majority of those targeted persons, listed persons, they are very, very big companies, and big companies definitely they have lots of funding internationally. It's quite logic that these contracts they encompasses arbitration agreements. This is how, you know, the disputes when arise, we come to commercial arbitration. In terms of the impact to the parties, so it might be to both and to claimants, and claimant can be sanctioned, and in some situations defendant also can be sanctioned. And disregarding whether it is institutional or ad hoc arbitration, the impact for both claimants and defendants, if they are under sanctions, quite significant. In terms of information requirements, so for example, if you are a claimant and if you are sanctioned claimant should bear in mind that before starting information should already have in hand collected all important information, which is most likely to be asked by arbitration institution, which is administrating appropriate case, or in ad hoc arbitration situation by an appropriate arbitrator, for example, before his or her appointment. And also it could be that time to time some information is required. What kind of information? That is, if claimant is sanctioned, it could be information on the related entities, on ultimate beneficial owners. So if this information is not at hand before claimant wants to initiate some arbitration, it might have delays in commencement of the arbitration. For example, institution might refuse to register the claim, or the arbitrator might, for example, reject appointment. Also, the impact could be and is definitely a huge impact to payments. In terms of in absolute majority of the cases, it's necessary to get various licenses for those that under sanctions persons. Again, absolute majority of most important or mostly used arbitration institutions, they do have already in place various policies, guidelines, notes, rules. They have agreements with their countries that would allow them to proceed more smoothly with the payments. For example, PCA has agreement with Netherlands that allows quickly to get the license and smoothly to proceed with the payments. But this should be held in mind by the parties involved, sanctioned parties involved in arbitrations. And should be remembered that we're talking about payments, administrative payments, arbitration fees, legal costs, expert costs, and any other payments. And then in ad hoc, it would be the same. the same kind of in fact effect if we're talking about arbitrators in absolute majority situations under EU and UK sanction policies. Arbitrators are exempted from the getting license, but in some particular situations, nevertheless, arbitrators, they also should apply for license in order to get payments. I already talked that the involvement of sanctioned persons might significantly delay proceedings, and not only sometimes delay, but even could lead to the discontinuation of the proceedings, or in some cases the claims could be deemed as withdrawn. In the latter situation, such kind of sanctioned persons should bear in mind the limitation of periods. So if you are not ready to pay appropriate payment within the established deadlines, for example, it may lead to discontinuation of the proceedings. Your claim might be deemed as withdrawn. And if later on you would like to start a new case, then already maybe time limits could be passed. And last but not the least, so from my side, so again, if we're talking about our part of the world, which means very close to Russia. So Russia is creative in the sense that they have enacted their own laws. The most, let's say, famous is from 2020, where they said that the Russian sanctioned entity, they can disregard arbitration clause. They can disregard any other agreement on the forum which is laid down in the appropriate contract, and they can go straight to the Russian courts, and Russian courts can issue, even if arbitration is started somewhere or prior to arbitration. So, and then of course, probably most likely the opponent would not come to Russia or would not participate in the Russian proceedings. Then it means that maybe the opponent would start, for example, in ICC, if ICC clause is foreseen. So then it would involve in two parallel proceedings. Then the question is that ICC abort what most likely will not be enforced in Russia, and vice versa. So such kind of laws, they're making lots of mess in our daily life of arbitration, which was quite subtle in that terms. But there are really lots of ways to fight with such kind of again, my personal opinion, with such kind of unfair behavior of the sanctioned country, where the lots from which aggression against Ukraine have started.
Thank you very much, Vilija, for this whistle-stop tour. Natalie, just touching on what Vilija said, and the controversial Enemies Act enacted in Russia, that affected the arbitration clauses, at least under Russian law. From the common law perspective, what impact do sanctions have on the validity of arbitration clauses and therefore jurisdiction?
It's an excellent question, Karolina, because given the increased incidence of these kinds of disputes and the way in which, as Vilija has mentioned, the grappling with sanctions is and will remain a key issue, you can anticipate creativity in arguments from parties who find themselves constrained by the realities of sanctions regimes. That creativity, for example, we've seen in England in a recent case there involving a commercial dispute between Barclays Bank and VEB, which is, the State Development Bank of the Russian Federation. One point that I will make, a lot of the discussion of sanctions these days, is in and around and involves Russian entities, but there are, of course, a number of other states, entities, organizations that are targeted by sanctions. So I will try to think of examples involving other countries. But, sort of the Barclays and VEB case was an example of just such a creative argument, right? Where the respondent in that case, which was the Russian entity, argued that, sort of the overwhelming impact of sanctions essentially meant that the arbitration agreement should no longer be viewed as valid and shouldn't be enforced in England, because I think the argument boiled down to it affected access to justice because of some of the constraints that we've talked about, and therefore so radically altered the arbitration agreement that it frustrated the very purpose of the agreement. The way in which the English court dealt with that is frankly the way in which I would anticipate that US courts would deal with that, and that courts in other common law countries, at least those that have a strong tradition of upholding and enforcing arbitration agreements and arbitration awards, would react, which is, that's a very nice try, but no prize. The court took into account the fact that there is a strong policy tradition and precedent in England, as there is in the US, for being an arbitration-friendly jurisdiction, and then went in to analyzing the specific arguments. And the bottom line is, there is no doubt that sanctions regimes will, for example, introduce delays, that they will constrain the ability to have the easy flow of funds that is necessary to pay arbitration advances, to pay arbitrators, to pay counsel fees, etc. And that will have an impact in terms of constraining the number of counsel who are available for these matters, potentially constraining the arbitrators who are willing to take on cases with those kinds of administrative burdens, and really focusing the attention of arbitral institutions on how they manage that. But none of that means that the arbitration clause is unenforceable. So that's what the English court held. That's what I would expect US courts to hold as well, although I'm not aware of a case that has yet presented the question. And frankly, from the perspective of an arbitration practitioner, I think it's the right result.
Thank you, Natalie. And personally, I do agree with you with the common law hat on. I think it'll be interesting to see how the civil law jurisdictions will handle it, since under at least English law, we do not have the notion of hardship unless written into the contract. So I personally think there will be developments in this space. And then staying with you, Natalie, for a while, you mentioned all the different challenges and issues thrown at arbitration institutions due to the sanctions. With your LCIA and ICC hat on, can you tell us about any creative adaptations that the institutions have introduced to handle disputes involving sanctioned entities?
Sure. So wearing both of those hats, the key question, I think, is really the way in which the institution interacts with the government entities and agencies that are involved in enforcing the sanctions regime, and then the guidance that is given to the users and the stakeholders in the arbitral process, whether it's arbitrators or users. So both in the United Kingdom and the United States, the way in which you deal with a financial sanctions regime is that you seek a license from the relevant entity. The trick is that a general license, so that the government says every kind of activity in this area subject to compliance checks is permitted? Or is it a series of, do you need to seek a series of specific licenses? And this is a big distinction between arbitral institutions and other players in the United Kingdom as opposed to the United States. There's a general license in the United Kingdom in the wake of the spike in Russia-related sanctions following the invasion of Ukraine. There is not a general license in the United States. So what we have seen under the general license, the LCIA, for example, is able to provide guidance to arbitrators to engage directly with the sanctioned entities that may be at play, and, for example, to put in a submission to the English court in the case that I just mentioned, explaining how those things are facilitated. In the US, the need for specific licenses, notwithstanding a pending request from a number of arbitral institutions that the relevant entity, so the Treasury Department's Office of Foreign Assets Control, or OFAC, reconsider and issue a general license. That is not the current policy or practice. And therefore, every person who is involved in the process the arbitral institution, arbitrators, law firms, and any other US-based person would need to apply for a specific license. So that does complicate efforts and sort of put that many more barriers that you would have to navigate. But as I mentioned, the critical issue, at least from the arbitral institution perspective, is once you understand the kind of license that you need and that you obtain it, is in then communicating the necessary guidance so that arbitrators, for example, have the information that they need to make the risk assessments to determine whether they would take on that kind of matter.
Thank you very much, Natalie. And Vilija, where does SCC or VIAC stand on the scale that Natalie just outlined for the US and UK on the other side?
Yeah, so as I think that already mentioned earlier, after this huge scope of sanctions, especially after 2022, main institutions, they passed their kind of guidance notes, various kind of assistance, you know, to the parties, because of course since the number of commercial arbitrations involving sanctioned persons are growing, so this is a correct approach by the institutions. So I think that it's very useful guidance by joint ICC, LCAA, and SCC guidance on the impact of EU sanctions. And I find it very useful. It's publicly available on the sites of ICC or LCAA or SCC. So, I know that in all those institutions, there is a quite really smooth assistance for persons dealing and applying for license and for getting any other directions. VIAC, I don't know whether they have a specific team dedicated to that, because in ICC and SCC there is dedicated teams. And I'm sure also LCAA is the same. VIAC, there are maybe, because it's a smaller administration, smaller institution, there is no specific team, but there are persons that again assisting. But as a general is the same as Natalie said, the main thing to move smoothly is getting licenses. And those institutions, they assist getting. Otherwise, if you don't get and you don't think in advance what is needed also to get license, again, it would impact very significantly the length of the proceedings, and the substantial delays might impact. I see in Q&A chat there is one question, but I think that after this session we will have Q&A session, and I will answer the question which is already posed.
That's absolutely right. Please stay with us for the Q&A session. There will be a link posted shortly. But before we move to the Q&A session, we saved the last important question for dessert. And it's on the topic of thinking ahead. And it deals with enforcement and execution of arbitral awards. So the question to you, Vilija and Natalie, is, how do you deal with enforcement of an arbitration award when you're facing a sanctioned entity?
Yes, so maybe I can start. I think that 4 things or 4 points should be considered and should be kept in mind. So the enforcement against the losing party which is sanctioned, and vice versa, could be the situations, you know, when the when and where it could be, in which country, in the country where the sanctioned person is residing, and country itself, let's say, is sanctioned, for example, in Russia, Belarus, or in some other jurisdictions. So the 4 points to consider is the enforcement of arbitral awards in favor of sanctioned persons could be regarded as a violation of public policy and could serve as a ground, according to New York Convention, to refuse recognition and enforcement. And to my understanding, it is absolute majority of dominating understanding in the whole Europe. Secondly, what could be the reasoning behind of such approach that this enforcement would be against the contrary to public policy? There are probably 2 main lines of argumentation that we can see from Lithuanian court practice. One is that Lithuania is part of EU. The EU regulations and EU legislation become a part of our law. So therefore, the enforcement or recognition of award, which is contrary to the EU regulation, would be also contrary to the public policy. And second line of argumentation that we can see from Lithuanian court practice is also the reference to our constitution and mainly to its principle of principles laid down in the constitution, such as respect for human rights, equality, solidarity, universality, and democracy principles. So then the question is, what kind of nexus you should establish in order to know that such kind of arbitral award should not be recognized? So whether it's enough that the merely person is from Russia or Belarus and awards in their favor would not be recognized in Lithuania? The answer is not. That according to Lithuania last court practice, the mere fact that company is from Russia and Belarus but is not sanctioned itself, it's not enough not to recognize such award. So in order not to recognize, it should be in the favor of sanctioned person. But thirdly, we should remember a very specific regulation towards the Russian sanctioned entities. And especially there is this regulation 269, as I said, financial sanctions, which say that if award was passed against in favor of sanctioned person before the person was sanctioned, such award should be recognized and possible to enforce, but the payment should be done in some kind of deposit account until that person is deleted from the listed, from the sanction list. And the last point that we have to consider is enforcement. And in fact, if recognition is not allowed, then enforcement also automatically probably will not be allowed, except this situation that I've just mentioned, with the exception, specific exemption in relation to EU regulation 279 in relation to Russia. And sorry, so then the last point is that, of course, nobody could believe that arbitral awards against sanctioned persons could be enforced in Russia and Belarus. So that also should be kept in mind. So before you start arbitration proceedings against a sanctioned person, for example, in Russia or Belarus, if those entities do not have assets outside their home countries, so it should be considered with a client very accurately whether to start this arbitration, because to enforce in their home countries, most likely it would be not possible. So in relation to enforcement, I think that these points should be considered.
Thank you very much, Vilija. And I propose that we ask Natalie for her views in the Q&A session, as I'm conscious of the time. Thank you very much once again, Vilija and Natalie. It was a fantastic webinar, and we're grateful for all the knowledge you shared with us. Our live webinar ends here, but we'll be back in 2 weeks with a podcast on corruption in commercial arbitration. So please do follow our LinkedIn and join our future recordings. For those of you staying for the Q&A session, you will find a Zoom link in the chat box. We would like to say a huge thank you to our partner organizations, in particular the AAA ICDR Asia Case Management Center and the Equal Representation Pledge in Arbitration. Thank you once again, and see you in 2 weeks.
Thank you.
Thank you very much, everyone.